paucity of time and also my limitations, various limitations, I will try to say only a few words because I know that we are running behind the schedule and much behind. So I would like to speak on this topic, dialogue between the two traditions on the idea of justice. If you carefully look at it, all the terms I have taken from either the theme of the conference or the theme of this session. Only one thing I added, and that is legal. That is not there. So my topic is dialogue between two traditions. These two traditions are not there. On the idea of legal justice. Justice can be of other types also, as I will tell you. So justice need not always be legal justice, but here, in the context of jurisprudence, of course it is legal justice. So this point I have added, otherwise all the terms have been taken from the themes already announced. Now how I relate them? The first point to remember is the terminology has to be made clear, otherwise we cannot follow it rightly. The terminology is jurisprudence. In what sense we use the word jurisprudence? Time is short, the word is very common, known. So I will very briefly tell you that jurisprudence is said to be philosophy or theory of knowledge, theory about law. But though this theory is theory about law, it also discusses and has to discuss the distinction between judiciable and non-judiciable laws or behavior. So this is therefore jurisprudence which deals with law, and one of the most important points to discuss in jurisprudence is the concept of law, the source of law, the scope of law, and many other things. So this is for the present the idea of jurisprudence. So far as the other things are concerned, say for example justice. What should be the meaning of justice? As I already told you, justice can be legal as also moral. So ethico-moral justice, and we have some corresponding expressions in our tradition, and also legal justice. Legal justice in our country does not mean just nyaya. For nyaya has many other senses and many other different types of nyaya are there. Basically, if we use the expression nyaya without qualification, it means Gautamiya nyaya or Annikshiki nyaya. This Annikshiki nyaya or Gautamiya nyaya is not the nyaya that we are discussing in the context of jurisprudence or law. We have a term, different term for it, and that term is Vyavahara. Vyavahara, if you so like, you can also add Vyavaharo nyaya, but simply nyaya is not what corresponds to jurisprudence. So therefore we have now here the Vyavaharo nyaya or Vyavahara. And the Vyavaharo has been defined in this way. In Mitakshara on Jadavpur, Vyavahara has been defined Onno Virodhena Satma Sambandhito Kathanam Vyavahara. Suppose someone says about a property, about a piece of land, this is mine. If someone else contests it and says, no, it is mine, then it is a case of Vyavahara. So Vyavahara means litigation, conflict of claims and counterclaims about a certain property. This is the scope of Vyavahara. So in this Vyavahara or Vyavahara Nyaya, that should be understood by the expression, this judicial Nyaya. Now the other word is the corresponding word is law and the standard or legal standard. What do we mean by that? So we mean that there is another word for it. We are discussing justice and just. In the legal sense also, justice and just do say for a person is just, an action is just. Justice is the property of all just actors. Our traditional terms for this is vidhi and boidho. So just is boidho and justice is vidhi or vidhi sammato. Vidhis can be of different types, and these different types of vidhis are dealt in with different shastras. For example, Vyavahara vidhi is the subject matter of Vyavahara Shastra. Dharma vidhi, subject of Dharma Shastra. In this way, different vidhis are discussed in different shastras. Similarly, Vado vidhi is discussed in Nyaya Shastra. So there are different senses of the vidhi, and these are to be clarified first, otherwise we may not understand what is the proper difficulties. So far, therefore, the point of discussion, or what I want to discuss is this, that the dialogue between two systems of law and application of law in the context of determining the legal appropriateness, legal fairness, and this has to be distinguished from other sorts of fairnesses. So, when we say vidhi or boidho, we always have to refer to in which context and in context of which shastra we are speaking of it. Are we speaking of it in the context of dharma vidhi, dharma, or sadachar? Sadachar and dharma is the same thing, and in many smritis, this distinction is the most important distinction between achar and vyavahara. Achar means sadachar and that is dharma, and vyavahara means the litigation or the law. So this is the difference. Now the point is that if vidhis are part of dharma as well as a part of law, that is vyavahara, occasionally the vidhis can conflict also, and both these apply to man and this situation. Then in case the two vidhis conflict, then how to resolve it? We have rather moved away from how to judge the action of a man in the context of litigation to how to decide the principles and provisions as to whether the provision is just or not. There is elaborate discussions on this, and very definite answers have been given, and that is this, that there is a priority and hierarchy of the vidhis. If there is a conflict between one vyavahara vidhi and the other dharma vidhi, then dharma vidhi will prevail over the vyavahara vidhi. The vyavahara comes under dharma. So that which comes under jurisprudence does also necessarily come under dharma also. So the system of law is not acceptable unless it conforms to the prevalent system of dharma or sadachar. So this is one point. But the question is, if two rather non-dharma vidhi, that is vyavahara vidhi, conflict, then how to decide it? This is another question that is being discussed in our jurisprudence or Vyavahar Shastra. And the answer is that there we have to apply our own judgment. Jukti or Nyaya. With the help of Jukti or Nyaya, so this shows the rational character of the type of jurisprudence we did have at that time. So we have to discuss it. To give an example, in the Srimad Bhagavad Gita, Arjuna was in trouble as to whether to engage in the battle or not. And he began with giving so many arguments why he should not fight. At one point he said, Papameva srayadashman hattaitan atutainam. And this atutai bodh is a matter of Arthashastra, and it is not a matter of Dharmashastra. Whereas ma hingshat sarva bhutani, it is a matter of Dharmashastra. So in this context, which should prevail? Should hingsha prevail or should not hingsha prevail? The provision of Arthashastra is, if there is some predator comes threatening your life, then without any discussion, without any examination or any hesitation, immediately kill that atutai. That is Arthashastra. But the other Arthashastra has to be limited because there is other Shastra, and that is Dharmashastra, which said no hingsha is permitted. So this is the way where Dharmashastra prevails over the Arthashastra belief. But where it is the only Arthashastra, two beliefs are in conflict, then we have to apply our judgment or Nyaya. So perhaps for this reason, some people think that Nyaya Shastra is the corresponds to jurisprudence, but that's not true. It is Vyavahar Shastra, and simply Nyaya means Gautamiya Nyaya, which is called logic or something of the kind. So what is exactly the difference between these two types of Nyaya? At least three important differences are there. The scope of Nyaya Shastra and the scope of Vyavahar Shastra are different. That is, the legal Shastra or jurisprudence and the scope of Nyaya, which is called a type of darshan, are different. In the Nyaya Shastra, scope is limited in terms of the topics it discusses. It discusses, as Gautama, the founder of this school, enumerated, there are 16 padarthas, main topics of discussion in the Nyaya Shastra. Whereas Manu has enumerated that in the Vyavahar Shastra, there are 28 main objects of discussion, of which the first is Rinodan. All that leads to litigation. And this 28 has been in Narada Smriti increased into 100 leads, and it has been suggested there can be many more. So the scope is altogether different. Here the scope is limited, but not only limited, different also. But there is another also difference, and the difference is in the nature. Nyaya Darshan is an adhvatik vidya. It is about the spirituality, even about the moksha. Vatsan has clearly said it, that it is Uddhatva Vidya, but also made a reservation. It is not Matra Uddhatva Vidya as the Vedanta or Upanishadis. Three is Matra Uddhatva Vidya, Nyaya Uddhatva Vidya with a difference. It is also a rational discourse. So it is not Matra Uddhatva Vidya, but Uddhatva Vidya nonetheless. And the third important point is the role of the two, the Vyavahar Shastra and Nyaya Shastra. The role of Nyaya Shastra is, it is subsidiary to, or it is an aid to. Its role is to help understand other vishayas. So Nyaya is Pradipa Sarva Shastranam. So it helps us understanding all the different shastras. And in this particular case, how Nyaya Shastra helps the Vyavahar Shastra and its application or practice. Nyaya Shastra can practice it in two ways. On the one hand, Nyaya Shastra provides us with a system of argumentation and reasoning. So when two different parties are contesting each other, then what should the methodology to convince another or to win over him? So it is said that Tattva Nirnay अथवा विजय दो ही न्याय शास्त्र का उपयोग है. So in the litigation, on the one hand we want to establish the truth by reasoning, and in the matter of establish the truth of tattva nirnay, now provides the means how tattva nirnay is possible. And it says vimishya paksha prativakshabhyam arthavadharanam nirnayam. So there is a method stated there. So it can help even a practicing judicial man, practicing lawyer, how to establish the truth in the context where there is many doubts, who is right and who is not. So this is one. But there is in another also, in addition to helping deciding this, the Nyaya Shastra also help it another way. Nyaya Shastra's contribution to Vyavahar Shastra is not just by way of helping it with the method of resolving the contesting parties, the contest. The lawyers of one party and the lawyers of other party, they contest with each other. But how to resolve for the judge which is the truth? Then he is to have some knowledge of the method which has been enunciated, elaborated in the Nyaya Shastra. But in addition to doing that, Nyaya Shastra has also richly contributed to the Vyavahar Shastra. And how that is done? On the themes of Nyaya, on the very pertinent concepts of jurisprudence, some Nayayikos have written vast tracts. So we should not simply remember that Vyavahar Shastra is only confined in the Samhitas. No. Apart from the Samhitas, there are many other commentaries also, and even in the Nyaya Shastra, many such people have contributed. And since in this particular center, the jurisprudence is getting so much of attention, I would suggest, if they have already taken note of it, some of the very important contributions the Nayayikos made in the form of, in the theory of Nyaya, and one or two such I remember, particularly one is Satto Janako Nyaya. There is Jadavpur Bhattacharya has written, in his name it goes in Jadavpur Bhattacharya's name, whether he has done it or not, I do not know. Satto Janakata Bad. On these two very important distinctions and texts have been written. That is, how, say for example, if father has died and his property is to be bequeathed to his sons and daughters and all that sort of thing. The idea is this, that the ownership was with the father. After the death of the father, does that ownership vanishes, destroyed, and ownership is created in others? And this ownership is created, then in which way the ownership is created and distributed? So one single ownership is distributed among many other people, and in which way, which would be the Nyaya and principles, that has been discussed. Very beautiful and very painstaking discussion is there. So, and there are other also tracts which are very rational. Say for example, Vyavaharo Mayuko. That is a very important text. So these are the three main ways in which Nyaya Shastra, Mani Gautamiya Nyaya, can be of help. But it is, though it is helpful, it is distinct from Vyavahara Shastra. It is not Nyaya Shastra, so we should either call the jurisprudence Vyavahara Shastra or Vyavaharo Nyaya Shastra, but not simply Nyaya Shastra. Having said that, by way of clarifications, then the question is now I should be very brief, so time is long. The point is that what is to be done about the two traditions, and these two traditions of Nyaya in the sense of jurisprudence. One is said here, the Vaidiko Nyaya, the Vaidiko Vyavahar Shastra and Western jurisprudence. Take us for granted for the moment that this distinction holds. One is Vedic jurisprudence and another is Western jurisprudence. For the moment, let us take that this holds. Then what will be the major difference? The major difference is this. This Western jurisprudence we call, though it has also a legacy from the time of the Greeks, still more or less this jurisprudence, Western jurisprudence is basically modern European jurisprudence. This modern European jurisprudence is rather is characterized by a few conceptions. One of these is this: the source of law and the effect of law. These are two very important points of jurisdiction to decide. In the Western conception of law, the authority and the source of law rests with the society. And this society, or the people living in a society, they not only create law, they are the authority of law, supporting law, and the basis is majority agreement. That is their way. But this idea was not in the Indian jurisprudence or Indian Vyavahara Shastra. It is not the society. For the reason is this, that society depends on law and not law on the society. That is our provision. And this is a common knowledge till the time of the early 19th century. That is during the independence movement. There is a very big issue being fought by very many people of that time. Say for example Rabindranath Tagore, Bankim Chandra Chattopadhyay, who is the composer of Vande Mataram, Mahatma Gandhi. What was the trouble going on there? The trouble going on there was that there are two groups of revolutionaries. One was the militant group and another was a pacifist group. So they were concerning what path is the right path. Should we take the pacifist path or should we take the militant path? Those militant revolutionaries, they were again and again quoting the Gita, and obviously wrongly, and that is this Nishkama Karma. That is not actually a case of Nishkama Karma, but anyway, every revolution used to swear by Gita. Bhagavad Gita was the very important text for them, they lived by it. But then, according to the Western tradition, the society determines the law. Here, those who are pacifists, they are saying that actually society is not prior, society is not the foundation. Our society itself is Dharma society. Dharma provides the very foundation of Indian society. Therefore, this Dharma includes therefore the beliefs that should not come from the society. Society does not support it, but this Dharma supports the Dharma. So this conversion of the view, that is very important way of differentiating the Vedic jurisprudence from the modern Western jurisprudence is one particular important point. So, apart from this, otherwise the things they are the same, that we want to have a society which will be just and impartial. So we say that in the Western tradition, everyone is the same, equal in the eyes of the law. meaning thereby everyone is expected to follow the law and not violate it. And then only in this sense, according to the law, either a person is wrongdoer or a person is not wrongdoer. So from this division of man in our society will be different, because we do not go only by legal principles but also by dharma principles, and that is moral truth. Morally just people, they actually were the authority behind this law. Jurisprudence has for its basis, laws are created and supported not by any person on the basis of democracy as we understand it, but it's a democracy without difference. Only well-versed, knowledgeable man of character, they would create Parishad, Dharma Parishad. They actually are the final authority in deciding and dispensing both the Vyavahara law and also of Dharma beliefs. So these are therefore difference. But now I come to the other two other points only. One is that now these two traditions that we have been speaking about, two traditions of jurisprudence, are there really two traditions of jurisprudence in India now? Since at least from 1776 onward, or downward, hardly there is any two system of jurisprudence in India. For what jurisprudence prevails in India now is basically the Western jurisprudence amalgamated into our ways. For since 1776, when the Gentoo law was collected, though it was collected from the Narada Samhita, Manu Samhita basically, but then all other laws that prevail is basically the British law. For at that time what happened is that though the laws were collected, but the law they collected were not actually applied. So when in the British government, towards the end of the company rule, the British government, that company court were established, both criminal and civil. Only criminal court could have an Indian judge, no Indian judge in the civil court. And not only that, there was a very clear distinction and a discrimination against the Indians, that Indian judge cannot pass any judgment on the British citizens. So at that time onward, that British rule, that is actually going on, and what now we say the Indian rule passed by the Indian Parliament, they have been already influenced by those ideas. Society makes the law by majority verdict, and all these sorts of ideas are coming down this. So hardly there is any VEDIC jurisprudence in operation now. So VEDIC here is only now one tradition of law, and that is basically coming both from inside and also the other procedures, that is British law. Now if this is so, then the only one tradition is operative. Then what happened? We have to see what happened since this transformation took place. And if we go from that time onward until today, we have to examine, notice and study properly with open mind what has happened. Many major events, many major litigations, many major judgments have come which will provide a scant respect for the Vedic tradition, a clear violation of Vedic tradition. Say for example, The oldest of this litigation was Shoti Rao. Then there was widow remarriage. All these are matter of great litigation and discussion. Then after that, there was Child Prevention of Child Marriage Act, Sharada Act, and even after that, the permission of MTP operation. All these are against the ideas, beliefs, practices and ideals of the Vedic society. So Vedic society that way is being neglected and forgotten. If this is so, then what we can do? Should we simply accept it and do nothing else, or we may try to do something? I think that nothing is gained if we become so pessimist. Even now we can try, and I think this center can basically address itself to this very hopefully, but realistically we must pinpoint and find out what can be done. The first thing that we should try to give up the attitude, the mechanical way of proceeding. We have to be very careful, very judicious, realistic, and see all that has actually happened. Where exactly we have deviated from the Vedic tradition of jurisprudence, the Vedic sense of justice, we have been deviated from that. And then where these are to be found even now? What are those Vedic episodes? What are the Vedic stories? What are the Vedic events, itihasa, where all these have been enunciated? They have been read with a changed mind, right approach and right understanding. If we do that, then only we can find what actually was the Vedic jurisprudence. We have lost the idea. We have no feeling, we have no knowledge of this Vedic jurisprudence. This has to be. To do that, we have to reorient ourselves, teach ourselves, make a very resolute decision, and in which way we have to proceed. And if we have to proceed, then I personally believe that if we can learn to reread our texts in the Vedic text, Ramayana, Mahabharata, Itihas, Purans, and Dharma Shastra, then we can first discover actually the strength, the three things. What was Vedic jurisprudence? What was the strength of it? What were the weaknesses of it? Having said that, we should try to rectify, reformulate and reinvent the Vedic jurisprudence, reorient ourselves to it. And in that case only we can find out that reaffirm our own tradition, otherwise there is no hope. The third thing is this. I can give one single example. Many examples are there. Only one example I will cite. In the Ramayana there is an event when Ramchandra killed Bali. This was rather highlighted to show how unjust was Ramchandra. I request you just to read that portion, very simple, but from the Valmiki Ramayana, and you will see this is one of the best example, highest example, exemplary example of judicial discussion, judicial reasoning, and we are rather just forgotten it, or we deform it, misinterpret it, deliberately misinterpret it to show that it is the failure of justice. If we reread it with the right kind of mind, you will see it is the best ever possible piece of juridical discussion and reasoning.